Appeal in the matter of Gas and Electricity Markets Authority and SSE Generation Ltd.
The message about not wearing robes maybe came a little bit too late, at least for some of you. But,
for some of us.
it looks as if you're all reasonably comfortable anyway.
And the air conditioning appears to be working, my Lords, which is always reassuring. My Lords, I appear for the appellant, the Gas and Electricity Markets Authority, or GEMA, with Ms Amy Rogers and Mr George Molyneux. Mr Tom Hickman QC and Mr Christopher Brown appear for the interested party, the CMA, and Mr Kieran Beale QC appears for the respondents, collectively we'll call them SSE. Just by way of the customary housekeeping, there should be, I hope your lordships have 7 bundles, 3 core bundles, 2 supplementary bundles and 2 authority bundles. Since those bundles were sent to the court, there has been an additional supplementary skeleton put in by SSE, dated the 13th of July, outstanding as an application to and rely upon
it was put in so late that my giving permission for it probably didn't reach the parties until this morning.
Well, it didn't reach me
at about 4:30 on Thursday, or Friday rather, from recollection.
Right, it hasn't yet reached.
It's shockingly late, but there we are. All a bit shambolic, frankly, but there we are.
Well, my Lord, I hope you have copies of that.
Yep, we've read
and that it's made its way into your bundles.
Yep. Yes.
So, my Lord, I will address GEMA's appeal against the decision of the learned judge below, allowing SSE's first ground of judicial review and quashing the CMA's decision in that regard. Ms Rogers, with your permission, will address SSE's cross appeal, which is against his lordship's dismissal of its ground 3A.
Yeah.
Now, subject, of course, to your lordship's views, we have discussed among counsel a timetable, particularly as we have an appeal and a cross appeal. So it's going to be a little bit backwards and forwards, subject to your views, my lord. Our proposal is that I will start and open GEMA's case on its appeal, followed by Mr Hickman for the CMA, which between us we should be finished by lunchtime, we hope. Mr Beale will then respond on our appeal and open his cross appeal this afternoon, and he thinks that will take until about midday tomorrow. We then propose that Ms Rogers respond for GEMA on SSE's cross appeal after SSE have opened on that, and also I'll make any brief submissions in reply, followed by Mr Hickman for the CMA, which will take us to about 4 o'clock tomorrow afternoon, which leaves some time for Mr Beale to reply on his cross appeal. We think it's better doing it that way than trying to load everything up front before we hear.
Is there any way in which you can speed things up a bit? We have read everything.
Yes.
There does seem to be a lot of documentation for what is, at the end of the day, as we see it anyway, some extremely narrow points.
My lord, yes, and I don't propose to take you to a great deal of the material that has been put into the bundles. I agree, it's relatively narrow points. So just in outline, my submissions will take the following form. First, I want to set the scene by summarising the domestic regime in this case, which I can do, I hope, relatively briefly, given your lordship's indication. Then I'll address the European legislative framework, which is at the heart of this case, and specifically what we say is the correct interpretation and impact of the ITC regulation on the charging regime in the UK. Then I'll address, again, as briefly as I can, the relevant background to the GEMA decision, which led to these proceedings, providing the context necessary to understand that decision and the CMA's subsequent appeal decision of the 30th of March 2021. And finally, having provided that background, I'll be able to explain very briefly our appeal, our grounds 1 and 2. So first, to set the scene, the details are set out in the GEMA decision and the CMA decision. A useful summary is also found in the witness statement of Mr. Self, Andrew Self, which was produced with a judicial review of Ofgem. I don't need to take you to it because I'll summarise the detail, but for your note, it's in Supplementary Bundle 2, tab 18. So in summary, this case is about transmission charging, Specifically, GEMA's appeal is about transmission network use of system charges, or TNUoS charges paid by generators. I'm afraid it's a feature of this market that there are a huge number of acronyms. The first acronym is TNUoS charges, transmission network use of systems charges.
Basic charges?
Sorry, my lord?
Can we call them basic charges? Does it really matter for the purpose of this appeal? I mean, it's...
Well, my lord...
The basics are, there is a basic charge. There are exclusions from it. The charge has to be within a permitted range.
My lord,
So the question
yes.
is, what are the exclusions and what's the permitted range, and was there one obligation or two obligations? And then did you have to comply immediately?
Well, my lord, yes. My only reservation about calling them basic charges is that our appeal is regarding TNUoS charges. The cross appeal is regarding different types of charges, the BSC charges.
Yes.
So, with your permission, I'll carry on using TNUoS charges, otherwise I'm going to do it myself.
The cross appeal is about whether or not they're within ancillary services.
Indeed, my lord, it's a different type of charge.
Then the cross appeal fails, and if they're not, it succeeds.
Yes, my lord. But they are a different type of charge, levied under
I
a different
understand that.
regime, under a different
It's even
code.
narrower than that. It's whether or not costs relating to management of interconnectors is relevant, or whether it's costs connected to the
Internal
system as a whole.
congestion. My lord, yes, but we'll...
That's what it boils down to, isn't it?
Yes, it is, my lord.
Yeah.
So, I think then I can take things relatively quickly. There is a distinction between the transmission network, which is the high voltage network that connects generators that are connected to the transmission system to the distribution system, and then there's the distribution system, which is the lower voltage network. The GB transmission system is known as the nets and is made up of onshore and offshore transmission infrastructure. The nets, or the NETS, is connected to continental Europe and to the island of Ireland by interconnectors. And in Great Britain, the nets is divided into the core part of the network, the main integrated transmission system, or MITS, and local assets. Local assets comprise local substations and local circuits. The nets, the National Electricity Transmission System as a whole, is operated by, but not owned by, National Grid Electricity System Operator, or NGESO, who is the transmission system operator under the code, TSO. The nets is owned and maintained by 3 onshore transmission operators, or TOs, and 20 offshore transmission owners, or OFTOs, each of the latter owning the infrastructure linking an offshore generator, usually a wind farm, to the onshore network. NGESO, who was an interested party to the judicial review below, operates under a transmission licence, which is granted by GEMA to NGESO under Section 6 of the Electricity Act 1989. NGESO's obligations under that licence include, by condition C10.2 of its licence, which for your note is at Supplementary Bundle 1, Tab 11, its obligations include maintaining what is known as the CUSC, the Connection Use of System Code. And that CUSC is the contractual framework for connection to and use of the NETS. The CUSC is contractually binding between NGESO and those who use the transmission system, including both generators and suppliers. And the CUSC...
Not GEMA, but not your client.
No, it's
Your
a
client's
contract
merely
between the
approved it.
private parties, indeed. Our client
Approved it, but
approved
it's not a
it.
party to it.
Yes. My lord, the CUSC includes a use of system charging methodology for use of the transmission network. And as I've already indicated, NGSO is also obliged to maintain the Balancing and Settlement Code, a different code, the BSC, and by that code it coordinates and controls the flow of electricity over the transmission system in order to maintain the physical balance of supply onto and demand from the network. All users of the nets, including generators, also have to sign up to the BSC. And the charges paid by generators in GB are calculated in accordance with both the CUSC and the BSC. And those charges that are relevant to this appeal and to the cross appeal are fourfold. First, there are CUSC connection charges. Second, there are TNUoS charges. Third, there are the balancing services use of system charges, which are the CUSC charges. And fourth, the balancing and settlement code charges, which are the BSC charges. For the purposes of our appeal, I will concentrate on the first two. Those first two, CUSC connection charges and TNUoS charges, are covered by the charging methodology under the CUSC. The others two are relevant to SSE's cross appeal, and Ms. Rogers will return to those tomorrow. First, it's important to bear in mind that CUSC connection charges are specifically defined under the domestic regime, and they're a different thing from transmission charges which fall within the connection exclusion. CUSC connection charges, with capital letters, are charges paid by transmission-connected generators under Section 2 of the CUSC. And they relate to the provision and maintenance of assets under 2 kilometres in length, so basically the initial cable, which is used by a particular generator and is installed specifically to link that generator to the substation. So they're the first 2 kilometres of cable, the connection, the CUSC connection charges, and they are specific to individual generators. They are domestic regime, under the domestic regime, and we can leave them for now. That's all you need to know. And they are to be distinguished from TNUoS charges, which fall within the connection exclusion. CUSC connection charges, by definition, well, we'll leave them for now. And as regards charges for use of the transmission network more generally, every year, GEMA carries out a price control process. And through that price control process, GEMA sets the maximum allowed revenue, or MAR, that transmission operators are allowed to recover. The onshore transmission operators are allowed to recover for installing and maintaining the transmission system. So there is a maximum allowed revenue that is set each year by GEMA. And that maximum allowed revenue is recovered through the TNUoS charges, calculated in line with and levied by NGESO under the CUSC. TNUoS charges are paid by suppliers on the one hand, and some but not all generators on the other hand. SSE pays TNUoS charges. TNUoS charges have to recover all of the maximum allowed revenue, either from suppliers or generators. And TNUoS charges are effectively the tariff or price which suppliers and generators pay for use of the transmission network. They're levied on a £1 per kilowatt basis, and for generators, they are paid by reference to what's known as their transmission entry capacity, or TEC. That is the maximum amount of electricity in kilowatts which the generator is contractually entitled to put on the transmission network at any one time. Now, historically, as I've said, the MAR has to be, the maximum allowed revenue has to be recovered as a whole from suppliers and generators. Historically, 27% of those revenues were recovered from generators, and the remaining 73% from suppliers or demand. That was known as the G to D ratio, or G to D split. However, and this is of importance to this case, since 2014, the proportion of TNUoS revenue payable by generators each year, as opposed to that payable by suppliers, has been set by reference to a formula contained in the CUSC. The CUSC calculation, as it's been known in the papers, that formula aims to ensure that average TNUoS charges payable by generators do not, on average, exceed the 2.5 euros per megawatt hour in any charging year. So that formula, what's been known as the CUSC calculation, has sought from 2014 to ensure that the upper level of the permitted range in the ITC regulation is not breached. So I will come back to the CUSC calculation. However, for present purposes, it's sufficient to note, my lords, that the impact of the introduction of that formula was to reduce the proportion of TNUoS revenue recovered from generators versus that recovered from suppliers. For the 2020-2021 charging year, generator TNUoS charges amounted to approximately 13.2% of the TNUoS revenues recovered, dropped from the 27%. So before I turn to the relevant EU legislation, just by way of background, I finally need to briefly address the CUSC modification process. This is the way by which the CUSC, the code, can be changed and modified. There is a complicated process set out in the CUSC itself and in the rules, but in summary, the standard process is it is industry-driven rather than regulator-driven.
And that is a problem for you.
And that is a problem for us. But it is an issue for us that has to be dealt with. I assume
one of the reasons why you're in the bind that you're in at the moment.
Yes, my lord. That's
You're going to come back to that because we've got some questions for you on your duties and obligations in relation to modification.
Yes, my lord, I will. And it specifically goes with respect, my lord, to ground 2, and I will address you on that. But just by way of summary, I think you already have this, but the standard process, and that which applied in this case, is that proposals for modification are developed by the industry representatives, as you say, and then submitted to GEMA for consideration in what's known as a CUSC modification report or final modification report, an FMR. An original proposal is raised. Here, the original proposal with capital letters was raised by Ngso. The then industry representatives meet in a working group to discuss and raise alternatives, more acronyms, the Work Group Alternative Code Modifications, or WACMs. In this case, 83 WACMs were raised.
84, wasn't it?
84 including the original proposal. 83 WACMs were raised with various permutations of the issues. Then the work group votes on the WACMs and the original proposal, and a preferred modification may emerge. In this case, however, there was no consensus on a preferred modification, so GEMA had to consider the original proposal and the 83 WACMs, as your lordship says, 84 different permutations that were presented to it in Ngso's report, the final modification report.
Are we right in assuming that none of the alternatives, I think it's under paragraph 8 of the code, actually permit GEMA at the end of the day to take its own decision?
That's our submission. I'll take you, if I may, my lord, to, it could make a decision, but it can't substitute its...
So own initiated decision then?
Yes, only in very limited circumstances. If I can take your lordship...
Well, I'm not certain in any circumstances, even under 823.7, which is the one the respondents rely upon to say that you've got the greatest freedom, there are still limits.
My lord, yes, absolutely. If I could take you then to, it sounds like your lordship is ahead of me, but if I could take you to supplementary bundle 2.
Yeah.
Yeah, supplementary bundle 2, tab 26, which sets out, contains the relevant provisions of the CUSC. And at page 456, you see the heading CUSC Modification Report, paragraph 823. This sets out the complex process, which I don't need to take you through in any detail until we get to page 460. And my lord sees, your lordships see at the top of that page, paragraph 8.23.7. And your lordships see that it provides, subject to various paragraphs which are not relevant in this case, the authority, GEMA, may approve the CUSC modification proposal or a WACM contained in the CUSC modification report if, however, the authority believes that neither the CUSC modification proposal nor any WACM would better facilitate achievement of the applicable CUSC objectives, there will be no approval. And then that's notified back to the CUSC parties.
But you can't say a plague on all your houses, we're imposing our own decision.
not, except in very limited circumstances set out in, yes, we say it can't, but just for completeness, my lord, if I can take you to condition 10.7a of NGSO's license, which contains a condition in effectively very similar terms, but in positive rather than negative. If, my lord, that's at SB Supplementary Bundle 1, tab 11. This is condition C10. If I could ask you to leave the second supplementary bundle open, and we'll just compare, if we may, what's in the transmission license in supplementary bundle 1, tab 11, condition C10. C10 7A, which is on page 182. Your lordships will see condition 10.7a, without prejudice to paragraph 13a, if a report has been submitted to the authority pursuant to the procedures described, and the authority is of the opinion that a modification set out in such report would, as compared with the then existing provisions of the CUSC and any alternative modification set out in such report, better facilitate achieving the applicable CUSC objectives, the authority may direct the licensee to make that modification. So a comparison is to be carried out between the status quo, effectively, and the proposals in front of the authority. And the test to be applied by the authority in carrying out that comparison and deciding whether or not to accept a modification or direct NGSO to make the modification is whether any of those modifications would better facilitate achieving the applicable CUSC objectives.
And the CUSC objectives include compliance with Annex B.
My lord, they do. For completeness, that's at condition 10.1 on page 162.
Sorry, which page?
I'm sorry, page 170, 10.1.
Oh yeah, there they are. Yeah, thank you.
Applicable CUSC objectives, same tab, page 170, the applicable CUSC objectives. You see in the introduction in paragraph 1 of condition C10, calculated to facilitate, again similar wording, calculated to facilitate the achievement of the following objectives, including at C, compliance with the electricity regulation and any relevant legally binding decision of the European Commission and of the agency. And I believe it's common ground that the ITC regulation is one of these relevant legally binding decisions, although it's not the electricity regulation itself as defined. And sorry, for your note, condition 5.5 on page 162 also sets out the ACOs, the applicable CUSC objectives, in pretty much exactly the same term. So, my lord, my lords, I make 2 points on these provisions. First, GEMA's powers in respect of the proposals in an FMR are limited. GEMA can approve a proposal included in the final modification report or can reject them all. GEMA cannot, as your lordship has already indicated, as you understand, GEMA cannot decide to impose a hybrid of the proposals or even some other modification of its own devising. GEMA does have a power to send proposals back for revision and resubmission, but only where it cannot properly form an opinion on the proposals in question. And my lords, that is paragraph 8.23.12 of the CUSC, which is in supplementary bundle 2, tab 26, page 461. So you can close, my lords, supplementary bundle 1, put that away. Supplementary bundle 2, tab 26, page 461. 461, tab 26, the paragraph 82312 of the CUSC sets out the power whereby the authority can send a proposal back for revision and resubmission. And it says, as you'll see there, if the authority determines that the CUSC modification report is such that the authority cannot properly form an opinion on the proposal or the WACMs, or where there's an EBR amendment, again, that's not relevant, it, GEMA, may issue a direction to the CUSC modification proposal, effectively saying that it needs to submit a new modification proposal, and it can require those to be drafted. It can require those to be drafted by reference to analysis or information it requires in order to form such an opinion, and requiring the modification report to be revised and resubmitted. But my lord, I make the point, my lords, I make the point that that is only where the authority has reached the conclusion that it cannot properly form an opinion on the CUSC modification proposal or any WACMs in the report.
If it's of the view that each and every one of the 84 proposals is non-compliant,
Yes.
then it has formed a view. It's not unable to form an opinion,
My lord,
but it
yes.
cannot take its own decision.
My lord, yes. Or if it forms the view, which it did in this case, we say that one of the proposals, although it doesn't, the original proposal does not reflect exactly the terms of the connection exclusion, it fulfills the obligation imposed by the ITC regulation, at least for the next 3 years, to ensure that on average annual average transmission charges fall within the
That's a
legal
slightly
range.
different issue, I think.
That is ground one, which is we formed the opinion, GEMA formed the opinion,
Yeah.
that it would not, that the original proposal would not breach what it says is the obligation under the ITC regulation.
Can we ask you this, which I think slightly puzzles us, as to why GEMA considers it's bound by a contract as opposed to its public law obligations? It's got obligations under the EU regulations to both apply the law and ensure compliance with the law, Articles 18 and 19.
Yes,
And yet it's tied its hands by approving a contract, which is private law,
yes, my lord.
not in a way which it considers fetters its discretion and hinders its ability to comply with its statutory duties.
Yes, my
Why is
lord.
it bound by a contract?
My lord, I may need to go back, and this was a point that, and I'll check if I may, the relevant statutory regime, which I don't have at my fingertips, because as I understand it, the relevant statutory regime sets out step-by-step process by which GEMA is allowed to make modification proposals, etc. So the CUSC is the creature of, it's quite complicated.
But it's approved the CUSC.
It has, my lord.
But it can always change the CUSC, and after all, it's the regulator. Why does it have to tie itself up? Even if it had to do it via the CUSC, why does it have to tie itself up in a way which it considers prevents it properly complying with its own statutory duty?
My lord, I'll come back if I may, because I think I need to refer you to the specific provisions of the Electricity Act, because as I understand it, the Electricity Act requires not only GEMA, well, it requires GEMA to grant a licence and to comply with the licence. I need to get this right. And then the licence itself requires the CUSC, but I need to get the steps right, if I may, my lord, and I'll come back particularly to you, if I may, on those statutory
There's a
provisions.
provision, I think it's in the 2009 directive, which sets out the regulator's powers and duties, which in relation to contracts says there's a duty to respect a contract, provided it doesn't hinder the obligations of to comply with the law. Article 37L. So we're slightly puzzled by how the regulator's got itself into this position where it doesn't feel it's got the relevant powers, because and when the fetter is a contract, we're just slightly baffled by why that is said to override the duty to both apply the law and ensure compliance with it.
Well, my lord,
As a matter of elementary public law principle.
yes, my lord, and I take your point. I think the position was slightly complicated in this case because GEMA took the view at the time of the decision, this is our ground one, and this is what the judge disagreed with us, but we took the view that the obligation imposed by the ITC regulation was just one of result.
Yeah.
So we took the view that having considered, and the result was simply to fall within, the averages fall within, the average charges fall within the range. So we took the view that the decision we were making was lawful, did comply with the obligations set out in the ITC regulation, at least for the next 3 years. We took on board the fact that in order to ensure that the permitted range is complied with, that this obligation is complied with, it is sensible to have a formula in the CUSC that exactly reflects the calculations set out in the regulation.
Well, we understand what, I mean, we understand all this. In a sense, we're jumping beyond that and saying you are where you are. Let's assume for the sake of argument something went wrong and you've got to remedy it.
Yes.
And you now think you know what to do.
Yes.
And you have to go through a procedure which prevents you from applying the law as you would see it. And that's what puzzles us, because that which fetters you at the moment seems to be a contract,
Yes.
which you have approved of, but
Yes.
you know, there may be legitimate expectations, issues arising, but
Yes.
it's procedural, and it's hard to see how that could prevent you from complying with your duty as you see it under the law.
Yes.
This is what puzzles us about the sort of public law structure, which is the tail wagging, the contractual tail wagging a public law dog.
I take your lordship's point, and I only hesitate because I don't want to refer your lordship to the incorrect sections of the Act.
Yeah.
If I may
Yeah.
come back to you on that point specifically, because I know it is a point. For the purposes of our case, we say that in fact that's an interesting and important theoretical point, but it is only a theoretical point in this case, because we say, and this is our ground one, that we did not feel
Understood.
that we were
Understood.
acting unlawfully. But if I may, I'll come back to you on the terms of the Electricity Act and how it
I guess what it boils down to, is there a power in the Electricity Act for GEMA simply to take decisions so as to ensure compliance with the law?
Yes. Well, my lord, we did produce a note for the court below on the relevant statutory provisions, because it is quite complicated how it all fits together, and I'll dig that out if I may, just to make sure that I'm getting it absolutely correct. But I've made my first point as to GEMA's powers being limited under these the CUSC, and the second point is the test that GEMA is to apply when deciding whether to approve or reject the proposals submitted to it. I made the point there's a question of whether the proposals would better facilitate achieving the applicable CUSC objectives than the status quo. Before I return to the particular context of the decisions, then if I can move on to the EU legislative framework. And again, as this is at the heart of the case, I need to take a little more time on this. Just by way of background, there were 3 relevant EU law measures that came into effect on the 31st of March 2011. They were first the 2009 Electricity Directive. I don't need to take you to that at the moment. For your note, a copy of the directive is at the Authorities Bundle 1, tab 2. It's sufficient for my purposes to go to the summary of that directive, which is contained in Mr. Justice Swift's judgment below. It's paragraph 8 of his judgment. First core bundle, tab 13, page 182. Core 1, tab 13, page 182. And on page 182, paragraph 8, the learned judge summarises the 2009 Electricity Directive, just for your note, that's authorities, bundle 1, tab 2. He says the first was the Electricity Directive, which set common rules for the generation, transmission, distribution, and supply of electricity, etc. And it makes provision for a national authority, regulatory authority, which in GB is the GEMA. The second EU law measure that came into effect in 2011 is the 2009 Electricity Regulation, which is summarised in paragraph 9 of the judgment below, page 183. For your note, that's found in the Authorities Bundle 1, tab 1. And that is primarily concerned with conditions for access to the transmission network and to facilitate cross-border exchange of electricity. However, it also contained provision about charges. There's the primary provision in Article 14 about charges applied by network operators for access to the networks. They have to be transparent, take into account the need for network security, reflect actual costs incurred insofar as they correspond to those of an efficient and structurally comparable network operator, and they have to be non-discriminatory. And they're not to be distance related. Paragraph 18 gives the power for the European Commission to issue guidelines on matters within the scope of Article 14 on charging, and 18.2 is the relevant provision. And it's there set out. The guidelines may also determine appropriate rules leading to a progressive harmonisation of the underlying principles for the setting of charges applied to producers and consumers under national tariff systems, including inter-transmission system operator compensation. And by Article 19 of the 2009 regulation, you'll see at the end of that paragraph, national regulatory authorities were required to ensure compliance with the regulation and the guidelines adopted pursuant to Article 18. And the third of the measures that came into force on the 3rd of March 2011 is Commission Regulation 838/2010, or as it's been known in most of the documents in this case, the ITC regulation. And I would ask you to turn that up because, of course, that is at the heart of the case. And that's in Authorities Bundle 1, tab 3. Authorities Bundle 1, tab 3 is the ITC regulation, Commission Regulation number 838/2010 on laying down guidelines relating to the inter-transmission system operator compensation mechanism and, which is relevant for our purposes, a common regulatory approach to transmission charging. Before we look at that directive in detail, can I just make the following introductory points? First, your Lordship should note, and it's reflected in the judgment below, that the 2009 regulation and the 2009 directive were repealed and replaced by updating legislation and updating regulation and directive in 2019. The ITC regulation, however, this regulation, 838/2010, remained in force. For the purposes of GEMA's appeal, nothing turns on this, but it's relevant that your Lordships have that background. Also relevant background, of course, is that the ITC regulation is a provision of retained EU law. So after Brexit Day, it was retained and amended so as to apply only to GB and the UK by the regulation which you find at tab 4 of the Authorities Bundle, the following tab. Again, I don't ask you to turn to that because I think it is uncontroversial that all that did was effectively take out the references to the EU generally, to the EU regulator. But
is the reason it's GB is because the position of Northern Ireland
Northern
is
Ireland,
critical.
yes, there is a single Ireland network. So it's GB, not UK. So, my Lord, if I can then focus on the document which is at tab 3, the ITC regulation itself. If I could ask you to start by looking at recital 10 on page 64. And after the various recitals dealing with intertransmission system operator compensation, we then move to the common regulatory approach to transmission charging as per the heading. Recital 10, variations in charges faced by producers, that's generators of electricity, for access to the transmission system should not undermine the internal market. For this reason, average charges for access to the network in member states should be kept within a range, which helps to ensure that the benefits of harmonisation are realised. So we're going to make a number of points about that. First of all, this is explicitly about average charges. I'd ask you to underline the word average. That they should be kept within a range, and that simply helps to ensure the benefits of harmonisation are realised. And I will show you what I support for my argument, which is this is clearly only about partial harmonisation, not full harmonisation of transmission charges. So then, if you could
That's
turn...
the only recital which is relevant, I think, to Article 2, isn't it?
I think
All
so,
the rest
my
are really
lord.
related to hosting in Article 1.
Absolutely, yes, my lord. So then Article 2 on page 65. Yes, Article 2 on page 65 simply says that charges applied by network operators for access to the transmission system shall be in accordance with guidelines set out in Part B. So we then turn to Part B. Part A deals with the inter-transmission networks. Part B on page 70. And your lordships will see that it sets out, or the heading here is guidelines for a common regulatory approach to transmission charging. And if we could just break down what's in this Part B to the annex, because this is contains the substantive obligations imposed by the regulation. If I can focus first on point 1, and that says annual average transmission charges paid by producers in each member state shall be within the ranges set out in point 3. Now that imposes a requirement that annual average transmission charges paid by generators must be within what we've called the permitted range. I would emphasise the words average. I would emphasise the fact that this is producers in plural. So in our submission, this must refer to charges paid by producers or generators collectively, on average,
Over a 12-month period.
over a 12-month
Yeah.
period.
So that assumes, so by its very nature, you're looking at an aggregated process over a 12-month time period for all producers. You set charges ex ante, but you presumably there's some form of reconciliation, either as it goes along or at the end of the period, and then some adjustment factor to work backwards to ensure compliance.
I will take your lordship to that, but essentially that is what happens, yes. So
throughout the 12 months, the right might be compliant, non-compliant, compliant, non-compliant, but at the end of the day, there's a flattening process.
yes, my lord, but also what's important is that even at the end of the day, there is no requirement that any individual generator pays any particular charges calculated in any particular way.
No, all it is,
Because
it's a fraud
some
receipt.
can pay above the average, some can pay below the average, as long as the average
Yes, but they have to-
collectively.
yeah.
It's an average across the board over a 12-month period,
Yes, that's a simple.
assessed after the event.
Well, we say it necessarily has to be assessed after the event. We also set charges ex ante in order to try to ensure that anything that happens, that it's,
You have to,
it has to
adjust
be
that, so
there has to be a reconciliation process, and I'll come to that if I may.
But your point is the only thing that the legislation at EU level does is impose a floor and a ceiling, and that's common ground between the parties, but the dispute is as to whether there's any other conditions.
Yes, we say it imposes a floor and a ceiling, but what does it impose that floor and ceiling on? It imposes it on annual average charges collectively across the board. So no restriction on what any individual generator can or cannot be charged, because it's an average across all generators. No restriction on the process by which the national regulatory authority sets charges for each individual generator. Just that they must on average fall within the range of that, for that period, that annual. Each year they must fall on average within that range. So that is point one, and we say that imposes the obligation.
No time period over which you must secure compliance. It must be averaged over an annual period at the end of the day. But in order to get to that, it doesn't say you must do it monthly or 6 monthly or within 18 months or 2 years. It simply says the end result over a 12-month period must be as per Annex.
So, my lord, in the UK, and again this is the domestic versus the EU, we have a charging year which starts at the beginning of April each year. So for each of those charging years, from April to April, we say the obligation that is imposed on the national regulator is to ensure that charges in aggregate on that, for that charging year, average out somewhere within this range. And that's simply the obligation that is imposed by EU law. It's a relatively simple point, but it obviously has not, it's given rise to a lot of controversy. What is important is that we say the obligation itself is simply what's contained in point one. Point two, we say, let's break it down. The first sentence says that annual average transmission charges paid by producers is annual total transmission tariff charges paid by producers divided by the total measured energy injected annually by producers to the transmission system of a member state. So we say that simply defines what annual average transmission charges means for the purposes of the obligation in point one. It simply sets out the method of calculating what the annual average transmission charges are in any particular member state for any particular year in order to enable determination of whether or not those annual average transmission charges fall within the range. And in order to do that, we're simply told you should divide annual total transmission charges paid by producers by the total amount of energy injected onto the transmission system. So again, a relatively simple point. We say that is all that point two does. It simply says this is what annual average transmission charges means, this is how you calculate them. And a further refinement of that calculation or definition is found in point two, second sentence. For the calculation set out at point three, transmission charges shall exclude 1, the connection exclusion, and 2, the ancillary services exclusion. So what does the second sentence of point 2 do? We say again, it doesn't impose any separate obligation. It simply sets out or identifies.
Say separate, do you mean an obligation or a separate? Does it impose any obligation?
What it imposes is how, and I suppose it could be said to be an obligation on the member state, on the regulatory authority, as to how it is to work out whether the obligation in point one, the obligation to remain within the range, has been met or not.
If you don't comply with the second sentence in terms of defining transmission charges, how can you comply with either sentence 1 or sentence point 1 or point 3?
Well, this begs the question, what do you mean comply with?
If
My lord, yes, by at the end of the year, your lordship Lord Green has posited that there has to be a reconciliation process at the end of the year, for example. And yes, when the regulator carries out that reconciliation process, we accept and have always accepted that in doing that, we apply the calculation, including the connection exclusion and the ancillary services exclusion.
Over what time period are you expected to comply? You say you can do it in 2 stages. They say you must do it once and instantaneously, and the judge agreed. But you say, all right, the first stage wasn't complied, but it was interim. You would have complied by the time the second stage And there's nothing in this which says we've got to comply instantaneously. Doesn't it boil down to that?
My lord, well, yes, and the question is how can one comply instantaneously?
Right, we understand that, but
In
that's
the
the
point,
difference
when
between-
you are setting tariff charges for individual generators in the CUSC, and your obligation relates to an average of charges across the board for all generators.
But
So-
it's simpler than that. The question is simply instantaneously or in stages. How do you get to compliance? You both agree you've got to get to compliance. Do you do it instantaneously now, as the judge said, with all the consequences which flow, or in 2 stages, now, which is the NG proposal, and then in future get to compliance? It's a staging post along the way.
Well, my lord, and again, the judgment below was, with the greatest respect, slightly unclear on this, because in our submission it suggested, could be read as suggesting there was some obligation to reflect this calculation not only on average across all producers, but on in the individual charges imposed on any particular generator. That's paragraph 40. And with respect, we say that that must be wrong, and I'll come to that. That's obviously wrong. The argument that was put by SSE, and it will be for counsel for SSE to develop this argument, was that not only does this Part B impose an obligation on the regulator to carry out the assessment as to whether the charges are within the range by applying a particular calculation, which we have always accepted, but that calculation and that connection exclusion aspect of the calculation has to be reflected in the CUSC, because they say our approving an amendment to the CUSC which contains a slightly incorrect definition of the connection exclusion is itself unlawful.
But you just simply say it doesn't matter because we'll get it right in stage B as opposed to stage A.
Well, my lord, yes.
But
And
that-
in fact, it would almost, it's difficult to see how you can get it right at stage A when the fundamental difference between the CUSC and this directive is the CUSC sets a price that each individual generator has to pay for each kilowatt of energy they inject onto the system. That is totally different from the nature of the obligation that is imposed by the directive, which is that on average, all charges paid over the course of a year by all generators fall within a range.
And
So-
that's why the reconciliation at the end
My
of the
lord,
day is
yes.
important.
Almost by definition, this cannot be done instantaneously in a code that sets an individual price for each generator for each kilowatt of energy they put onto the system before we even know how much they're going to put on, or how much will be, whether or not how much energy is actually injected onto the system over the course of the year.
Does it boil down to this? You say, looking at Annex B, it's minimum harmonisation, it sets the floor, it sets the ceiling. At some point in time, the exclusions have to be catered for in a mechanism in order to bring this matter to compliance. We chose to do it in 2 stages, which was pragmatic and consistent with the system. A, apply the NG proposal, which was nearer than anything else. B, in the future, get to complete compliance.
Yes, and a third element of that was not just apply the original proposal, which was as near as damn it, but require NGSO, do that now, and require NGSO once we had explained in Annex 2 to our decision how we said the connection exclusion should properly be interpreted, require them to come back with a further modification proposal so that the ex ante setting of the system exactly reflects, the calculation. There will still be a need, though, my lord, for an ex post reconciliation, even if the ex ante charging methodology exactly reflects the connection exclusion, because there will still need to be the reconciliation at the end of the year in order to determine what, on average, the charges are, because during the course of the year there may be differences in the amount injected onto the system, which could not be anticipated when the charges were set ex ante.
So
And
the only
there was-
thing that splits you is the timing over which the decision has to become correct.
My lord, effectively, yes.
And that then boils down to the interpretation of Annex B.
Yes, my lord.
What does it tell you? How does
Absolutely,
it tell
my
you to
lord.
comply?
And just to deal with, because we say not only is Annex B clear on its face, it's clear when you look at the Travaux Preparatoires as well, absolutely crystal clear, and I'll take you to that if I may. So my lord, there is a point that I do need to deal with, however, which is and your lordship will all have had experience of this, the faintly in felicitous drafting or typos or whatever you want to call it in European legislation, which is the reference in the second sentence of point 2. We have point 2, with the second paragraph, it says, for the calculation set out at point 3, transmission charges shall exclude 1, 2 and 3, connection exclusion, the ancillary services exclusion, and the system loss charges, which we are not considering here. Obviously, strictly, there is no calculation set out in point 3. Point 3 simply gives you the range for GB and Northern Ireland, which is the range of 0 to 2.5 euros per megawatt hour. And again, we think all that we can, the best we can do with that is to say that point 3 has to either be a typo or some infelicitous drafting, because the calculation strictly is the calculation set out in the preceding paragraph, the first paragraph of point 2. And we say that's made clear by the Travaux, and there are 2 documents I want to show you about the Travaux, for the Travaux, and they're found in.
Perhaps it just relates to my Lord Roger's Snowden's point, which is for the purpose of calculating the range, you've got to make sure the components that you're applying are consistent. So you build in the exclusions, you check to see whether they're against the range.
Yes. Well, my lord,
That's-
You can't, as it were, game the range by including stuff that you're not allowed to include.
yes, right.
Does it matter whether the reference should be to point 3 or to the first sentence?
Well,
of
my
point
lord,
2?
some
It's all the
arguments and
same
some time.
calculation, isn't it?
My lord, I agree. Some argument and some time was spent on this in the court below, but I totally
Speaking for
agree with your
myself, I
lordship, so
can't
there
see the
really
point.
isn't
Can't see any
much
point to it.
in this point. But my lord, I would like, if I may, to take you to the Travaux, because it is important. It does, I say, make the situation crystal clear. And if I can take you first to.
Well, I mean, but if you just left out the words for the calculation set out at point 3, if in a more English drafting style you just put, quote, transmission charges, unquote, shall exclude, then that's what it means. I mean, and if there's something turns on the reference to point 3 and it isn't point 3, well, what do? Just ignore all the words?
Well, my lord, and yes, and your lordship is absolutely right, but the approach that you might
One
take.
calculation here.
Yeah,
Yes, there's one
calculation.
If there were 2 calculations, then this would all be of some relevance, because you need to establish which calculation is being referred to. There's only one calculation.
Absolutely, my lord, and as your lordships will be well aware, and we don't need to make the point, the
we need
approach
to
that
look
one
at
takes
that?
to interpreting a piece of European legislation has to be a little more flexible.
Does it go to this?
No, it goes to much more than this. It goes to what the obligation is. So it is worth taking you, if I may,
Where's
to
that?
the Travaux. So if we can do go first to the supplementary bundle tab 1. There are 2 pieces of the Travaux that are important, and they are found at supplementary bundle 1, tabs 1 and tab 2. And just to explain what the document is, at tab 1 of the supplementary bundle, you will see that these are the guidelines on transmission tarification, which were produced in 2005, so prior to the ITC regulation. They were produced under, you'll see from the first paragraph under the heading background, These guidelines were produced under Article 8.3 of what was then the Electricity Regulation 2003, under Article 8.3 of that, which provided for guidelines to be adopted. The 2003 regulation was replaced by the 2009 regulation, and the reference to guidelines in Article 8.3 of the 2003 regulation was replaced by Article 18.2. So these are the pre-existing guidelines. And these guidelines were adopted, you'll see from the following document I'll take you to, without substantive amendment, as the guidelines contained in Part B of the annex to the ITC regulation. So they were in the form of a non-statutory guidance, and the effect of the ITC regulation was effectively to put them into statutory guidance form. And the only paragraph I need to take you to in this document, it's very short, is on the guidelines on page 7. The guidelines themselves, preceding pages are setting out the background. The guidelines themselves are found on page 7 of the bundle, and the first paragraph, which in our submission makes it crystal clear, insofar as there is any confusion caused by the reference to point 3, that the value of the annual national average G, that is the annual total transmission charges, is annual total transmission tariff charges divided by total measured energy injected, and annual average G shall exclude any charges paid by generators for physical assets required for the generator's connection or the upgrade of the connection, as well as any charges paid by generators related to ancillary services, or the third exclusion of specific network loss. So it's addressed in a slightly, I say, clearer form there, but it makes it clear what the obligation is.
I.e. you wouldn't have referred to a calculation at all, you'd have just followed that.
My lord.
Just take the words out.
My lord. So that's the only point on that document. The following document at tab 2 is, in my submission, slightly more, requires slightly more consideration. And if I could ask you to turn to that document. This is the impact assessment you'll see on page 9. It's the working document that accompanied the proposal for the ITC regulation. So it's a classic piece of travaux préparatoire for the ITC reg. And if I could
It's an
take...
internal commission document, is it, Trevor?
It's a commission regulation. So it's the working document that sets out the Commission's view on what the regulation is to provide. It is a Commission regulation, sorry, I get that right. And it's a Commission regulation because it is produced under the powers in Article 18 of the Council Regulation 2009. So it's the impact assessment for the Commission staff working document. And if I could ask you to turn in that bundle first to page 20. And sorry. Apologies. First of all, if I could ask you just to set the scene by turning back to page 12. And under the heading at the bottom of page 12, you'll see heading 1.2, tariff harmonisation. That refers to Article 8.3 of the 2003 regulation, which was what was in force when this document was produced. And it refers to guidelines produced under the 2003 regulation. And the second paragraph, the first full paragraph on page 13, ERGEG agreed draft guidelines in relation to tariff harmonisation in 2005, which have been implemented on a voluntary basis. That's the guidelines you've seen. The consultation requested the views of stakeholders as to whether the consultation on the ITC regulation, this consultation, requested the views of stakeholders as to whether the current voluntary approach should be continued. whether the 2005 draft guidelines should be adopted as binding guidelines or whether amended guidelines should be adopted. So those were the options open before the ITC regulation came into force. Keep with the voluntary approach under the 2005 draft guidelines, adopt them as binding guidelines, or put in place amended guidelines. And then if I can ask you to turn to page 20. Page 20, at the top of the page under the heading Tariff Harmonization 2.3. As noted in section 1 above, proposals for a guideline on ITC, inter-transmission connections, also address the issue of tariff harmonization. It explains what those tariffs are. And the last paragraph on that page is relevant. It talks about ensuring competitive neutrality between generators in different countries. And it says, in view of this desire to ensure competitive neutrality between countries, the regulation envisages that the network costs be recovered predominantly through charges imposed on consumption, that is, charges imposed on suppliers or demand. You'll recall I said there was a split between recovery of the costs of the transmission network between suppliers and demand. However, a lower proportion of total costs charged on network users may be recovered through charges on generation. And then, if I can take you to, on page 21, fourth paragraph. And it's talking about harmonization of G charges. That is, charges for access by generators rather than load charges is more important, since electricity production facilities and the location of production facilities are generally more responsive to price signals. Focusing on the absolute value of transmission tariffs for generators, rather than harmonizing the basis on which costs are calculated and the proportion of costs allocated to generators, can ensure equivalent outcomes, but still facilitates local TSOs and regulators taking account of local circumstances. This is the approach recommended by ERGEG in the draft guidelines. So the approach is focusing on the absolute value of transmission tariffs for generators, rather than harmonizing the basis upon which costs are calculated. And then it explains in the following paragraph, last sentence, the draft guideline prepared by ERGEG represents the consensus view as to the appropriate level of harmonization. Then if I can ask you to turn to page 29. Page 29, under the heading 4.2, transmission tarification, it sets out there the three options that are, well, five options in fact, that I've already highlighted. There's the options in relation to transmission tarification are no action, so the guidelines conclude there's no need to go beyond what's already stated in the regulation, that's Article 14. 2, adopt the 2005 draft ERGEG guidelines. Amend the 2005 draft guidelines, that's option 3. 4, introduce Ramsey pricing for load. 5, establish detailed rules setting out how the national regulators should carry out the assessment of actual costs, which corresponds to those of a structurally comparable operator and the proportion of costs to be recovered from generators. Those are the 5 options, and if you turn over the page, you'll see that on top of page 30, Ramsey pricing option 4 is rejected. And just above the heading, number 5, therefore only options 1, 2, 3 and 5 warrant further consideration. So that's no action, adopt the 2005 guidelines, amend them, establish detailed rules. Those 4 options warrant further consideration. Then if I can ask you to turn to page 32, it explains which of the options is chosen. At the bottom of page 32, under the heading 5.2, transmission tarification, currently national regulators apply transmission tariffs on generation in accordance with the national requirements in terms of providing effective locational signalling and general environmental requirements. They generally do so within the bounds of the 2005 draft guidelines, to which all regulators agreed. Overall, there's been a tendency towards transmission charges being set at zero since the beginning of the liberalisation process in Europe. So this recognises the pre-existing situation where national regulators set the tariffs so that they can take into account national requirements on locational signalling and environment, but they do so within the bounds of the draft guidelines. And then the first full paragraph on the top of page 33, the average level which the voluntary guidelines allow was set taking account of the fact that congestion between different systems means that prices do not equalise across Europe. For this reason, the conclusion of the consultation process undertaken by ERGEG in developing the voluntary guidelines was that there was some scope for variation in averages G charges without undermining the internal market. There is little evidence that this range of transmission charges currently has a negative impact on competition. So not only is there a difference between national charges, there's also a difference in the ranges regionally. And they say that doesn't seem to have an negative impact on competition. And then finally, the important conclusions that this document comes to on page 44. And this is, with respect, makes the position, as I see, crystal clear. Under the heading section 6.2, transmission tarification, the general presumption must be that, in accordance with the principle of subsidiarity, national regulators are best placed to set the appropriate level of transmission tariff for systems which they oversee. Nonetheless, as set out in the preceding sections, there are good grounds for establishing a framework within which regulators exercise their powers, and that's then referenced to the draft guidelines. If I could ask you, perhaps rather than me reading out, if I could ask you, my lord, to read the whole of that section and to mark up specifically the penultimate paragraph. So, my lords, we say that makes it clear that the EU legislator adopted what's described there as a framework approach. They made it clear that they were not intending to undermine the wide degree of discretion in setting specific charges that's afforded to national regulators. They explicitly rejected the approach, as it's described there, of focusing on the methodology underlying the calculation of tariffs. That's the first line of the last paragraph. That methodology is left to regulators, national regulators, to determine. The EU approach is to focus on outputs. So, my lord.
But you'd accept the subject to only those limits which are contained in Annex B.
Yes.
So whatever is in Annex B is the full extent of the intrusion into national pricing discretion.
Yes, ma'am. So we say it's clear from the language and the purpose of the ITC reg, as shown by the travaux, but with the language of the regulation itself, we say is also clear. The obligation imposed by the regulation, by Part B of the Annex, is simply to set annual average, to ensure that annual average transmission charges for generators fall within the range. Deciding whether they fall within that range, the regulator is to apply the calculation set out in point 2, exclude from that calculation charges for connection assets and ancillary services, imposes no obligation on national regulators as to how they are to set the specific charges. That's left up to their discretion. So, my Lord, then moving from the legislation to the relevant context for the decisions, because, again, how that regulation works in the UK and what was happening at the time of the decisions, to put them in context, it is important that I briefly take your lordships through that. As I've indicated, the CUSC methodology, so we're now looking at the domestic charging regime, as it stood before the decisions that were subject to judicial review were made, it included a mechanism which had the aim of achieving ex-ante compliance with the permitted range. That is the CUSC calculation. And how that worked is summarised in the CMA decision that was the subject of the judicial review. That's in Core 3, tab 24. So the decision is a substantial document, tab 24 in full bundle 3. If I could ask you to turn in that document to page 560 of bundle numbering. And on page 560, there's a section entitled Ngso Charges. Paragraphs 4.2 through to 4.6 set out what I've already summarised about the allowed revenue and how it's recovered, and the charges that are levied and on whom. Over the page, on page 561, paragraphs 4.6 to 4.7 explain in 4.6 that at the beginning of 4.6, generator Ngso charges, so the Ngso charges imposed on a generator, comprise 3 different types of charges: local charges, wider locational charges, and up to the year 2020 to 2021, generator residual charges, and explains then how they are levied, as I've already explained, by reference to the maximum amount of power a generator has a contractual right to put on the transmission system, the TEC. And then in paragraph 4.7, the levels of both local charges and wider locational charges vary according to the characteristics of the generators. And they're also intended to reflect local conditions, the costs of assets. And then under the heading, and the next section looks at transmission generator residual charges, or the TGR. And it makes the point in paragraph 4.8 that local charges and wider locational charges taken together don't necessarily fully recover all the costs, the relevant costs. So residual charges on both generation and demand have historically been used to recover the difference between the total of all transmission charges and the revenue that needs to be recovered. And the point at 4.9 is the point I've already made, that historically it was a fixed proportion of 27% to 73%, the generator demand split. And then paragraph 410 is the point I've also already made, that since 2014, the proportion of total Ngso revenues payable by generators each year has been set by a formula. This is a formula that we have described as the CUSC calculation. It aims to ensure that average Ngso charges paid by generators do not exceed €2.50 megawatt per hour upper limit of the permitted range being the range set out in the ICTC regulation in any charging year. The formula did not, however, deduct any charges pursuant to the connection exclusion. Under this approach, the proportion of charges payable by generators fell below 27%. As I've said, in the 2020-21 charging year, the generator to NUOS charges amounted to about 13.2% of NUOS revenues recovered. And this is an important point, my lord. Since the charging year 2017-18, the value of the TGR and therefore the generator residual charges have been negative. So it has resulted in certain generators getting a credit that's set against the local charges and wider locational charges that they are levied. And that negative value, therefore the credit to generators, including generators such as SSE, has been rising. And this change in the TGR has been at least in part attributable to increasing offshore local charges. Those are the charges related to the connection between offshore wind farms and the onshore grid, meaning a larger TGR reduction was applied, so the charges didn't exceed €2.50. Now, my lord, I draw your attention to this, first of all, to set the scene for the decisions that were made, but also because it makes it clear, as I have already said, that before the decisions were made, there was a methodology in the CUSC which sought ex ante to ensure compliance with the ITC regulation. And therefore, I just make the point that SSE is wrong to assert in paragraph 20 of its skeleton for this appeal that, I quote, the amendments which GEMA improved incorporated into the CUSC for the first time a definitive means of assessing the compliance of the GB charging regime with the ITC regulation. But my lord, there are two important points.
Can you help me?
Yes.
I think you've probably just explained it. One, I'm trying to understand the commercial imperatives which drive all of the various players in this. Perhaps it's relevant, perhaps on the SSE appeal about congestion charges. One way or another, the costs are recovered.
Yes.
If they fall into the heading that we're considering now, then they're subject to a cap. If they're outside of the cap, then they may go higher. Does that explain? I think that probably explains the dispute about congestion charges. That's what the CMA says at 8.1 here.
Yes.
But it's under which set of rules each cost is going to be recovered. Some are more constraining than others.
As regards the NUOS charges, the commercial imperative for generators such as SSE is whether the charges are to be, the revenue that's to be recovered, the TNUOS revenues, are to be recovered through charges on generators or on suppliers. The lower the proportion that is recovered from generators, the higher the proportion from suppliers. And so the connection exclusion goes to how that split is to be, well, first of all, the cap goes to how that split is to be set. And obviously the connection exclusion goes to how the cap, how much of the charges go into determining the cap.
So this somewhat bewildering array of different charging mechanisms creates a whole series of incentives as to whether you want to be in the charge or outside of it, or in the exclusion, or part in or part out, and so on.
Yes, my lord. And it's rather mind-bending as well to work your way through the caps and the exclusions from the caps and the... Yeah, but those are the commercial imperatives here. But there are also important, my lord, to make 2 points on the CUSC calculation, the formula, which I can, if your lordship wishes me to, take you through in the CUSC methodology itself. It is...
Maybe you could do that over lunchtime when we're not here.
Yes, I think that's probably... Yes, just talk into the void. The CUSC calculation is summarised here. What applied before the decisions at issue. There are 2 points. So that's what applied before the decision is at issue is called either the status quo, or in the decision it's called the baseline. And it's the baseline against which the decision and the options were assessed by GEMA. There are 2 points to be made about that baseline. First, I think the point you've already clearly got, the CUSC calculation was designed only to seek to prevent a breach of the top of the permitted range. It only took into account in the equation the cap of 2.5 megawatts per hour. The equation did not mention and never intended to try to ensure compliance with the bottom of the range. The second point is that although this CUSC calculation only looks at TNUoS charges, it's never included any BSC or PSUoS charges. They've always been treated by GEMA as falling outside the cap. The baseline CUSC calculation included all TNUoS charges, all the wider locational charges, and all the local charges, in order to determine what the annual charge was to be, to which the adjustment had to be applied to bring it under the cap. So all local charges, all locational charges were summed, in effect, ex ante predicted, on an ex ante predicted basis, and the adjustment was then applied to that sum by way of the transmission generation residual in order to bring the total sum below the cap of 250. And that's why the TGR, as the local charges went up, particularly because as the number of wind farms went up over the last few years, there's been a lot of local charges connecting wind farms to the onshore grid. The local charges go up, the cap, the sum, the lump increases, the adjustment that's made by way of the transmission generation residual becomes negative, because it has to pull the lump sum below the cap, and it becomes more and more negative. But all wider locational charges and all local charges were included in the baseline CUSC calculation. It did not exclude any TNUoS charges under the connection exclusion. In other words, put another way, it assumed that all of the wider locational charges and all the local charges were not charges for connection assets under the ITC regulation. So that was the baseline. None of those local charges excluded under the connection exclusion. The CUSC connection charges, those for the 2 kilometres of local cable, were excluded, but there's never been an issue about that. The local and locational charges under the TNUoS charges were not excluded, were all summed. There was no connection exclusion. None of those were held to be charges for connection assets. However, in 2018, in the context of another statutory appeal against the GEMA decision known as CMP 261, the CMA, which was not appealed, not judicially reviewed.
This was the EDF decision.
Yes, the CMA held that some local charges did fall, some TNUoS charges did fall within the connection exclusion in the ITC regulation. Specifically, the CMA held that charges for the offshore generator only spurs, that is the assets that were built in order to connect offshore wind farms to the onshore network, did fall within the connection exclusion. And so they should not be included for the purpose of calculating whether average annual generator transmission charges fell within the permitted range. For your note, this is dealt with in the CMA decision at 6.81 to 6.84. I won't take you to it. But the effect of this decision by the CMA was that the CUSC calculation, the baseline CUSC calculation, which treated no TNUoS charges as falling within the connection exclusion, was problematic in 2 respects. First, it calculated a higher figure for the lump sum of annual average transmission charges than envisaged under the ITC regulation, because it didn't reflect what we were now told in 2018 to be the correct interpretation of the connection exclusion. So the second problem is it set the residual charge, the TGR, at a level that was more negative than necessary to ensure compliance with the cap. So those were the issues that arose after the 2018 decision. However, at that point in time, GEMA had already initiated a significant code review as of August 2017. You may have seen reference to it, the Target Charging Review, or the TCR. That started in August 2017, and it looked at a number large number of aspects of electricity network charging, including but not limited to the reform of residual charging. And that is addressed in paragraphs 4.28 to 4.34 of the CMA's decision. That code review was underway. The CMA's 2018 decision was issued. Before the code review concluded, in May 2019, Ngso raised a proposal known as CMP 317. So that was before the code review was concluded, but it was after the CMA's 2018 decision. In 2019, Ngso raised CMP 317. That proposal was to amend the CUSC, and specifically the CUSC calculation, in light of, so as to reflect the CMA 2018 decision and to reflect the interpretation of the connection exclusion contained in that decision. However, CMP 317 was put on hold pending the outcome of the significant code review. In November 2019, GEMA published its final decision in the TCR, the code review, and it made a number of decisions. It was a broad, wide-ranging review. Among other things, independently of the issues that arise in this case, GEMA decided to set the transmission generator residual, the TGR, to 0, on the basis that the generation residual was only paid to certain generators and not to others, certain types of generators and not to others. So the credit that was now being paid to certain generators and not others as a result of the application of the TGR distorted competition between generators. So GEMA decided to set the TGR to 0. And it included that decision in the CUSC direction, which I will briefly take you to because various submissions are made as regards the impact of the CUSC direction, not just by SSE, but also by the judge below. This is the direction. It's at Supplementary Bundle 1, tab 7. And this, page 111 is the CUSC direction, and you'll see it's the authority directs NGSO to raise one or more code modification proposals in the terms, this is the penultimate paragraph, and for the reasons set out in the annex. It's dated 21st November 2029. There are a number of different directions resulting from this code review, and the one that's relevant for our purposes is on page 118. Paragraph 45, item 45. And that is the CUSC direction to which the learned judge below referred, and on which SSE relies. And item 45 instructs NGSO to raise a proposal that must set out proposals to modify the use of system charging methodology, section 14 of the CUSC, to set the generator residual to 0, subject to ensuring ongoing compliance with the ITC regulation, including the requirement that average transmission charges must be within the prescribed range. And that should be achieved by charging generators all applicable charges, having factored in the correct interpretation of the connection exclusion and adjusted, if needed, to ensure compliance with the range. In response to this direction, NGSO raised modification proposal CMP 327, which was subsequently amalgamated with CMP 317. And those two modification proposals, CMP 317, 327, were the subject of GEMA's decision of the 17th of December. I'll come to that decision, but before I do so, it's necessary to just pause and take stock of the context in which the decision was made. So as I've explained, pending the outcome of the significant charging review, the CUSC calculation had not been changed. So it contained no mechanism to exclude local charges which fell within the connection exclusion. such as the generator offshore spur or the offshore local charges. However, by 2019, the growth of offshore wind generation had led to a situation where estimated offshore local charges, which we now knew fall within the connection exclusion,
When you say charges, do we mean costs?
I mean the charges that reflect the costs of the assets, yes, because it's charges that the regulation regulates. Those offshore local charges had increased to more than £400 million a year because of the growth of wind generation. Including the error margin, that equated effectively to the entire annual amount of generator transmission charges consistent with the upper limit of the permitted range. So there was a lump sum of £423 million, which effectively took you to, accounted for, the whole lump that took you to the upper limit of the permitted range. So by applying the baseline CUSC calculation, which did not exclude those charges as falling within the connection exclusion, generators were being given a credit by way of the negative TGR, which effectively, if you applied the correct connection exclusion so as to exclude that 423 million, effectively brought their charges below the zero level of the permitted range, properly calculated. So that is the context for the decision, which I will take you to briefly. It's Supplementary Bundle 2, tab 14. It's the GEMA decision. So I'm not going to read it all out, obviously, but it's here at tab 14. It's the GEMA decision, and it's slightly more manageable than the CMA decision. I hesitate, but it's first, if I could take you to page 247. 246 sets out the background and the context. Tab 14, the first tab in the bundle, supplementary bundle 2.
No, I think our bundles, my bundle's been.
Oh, I'm sorry, they're different.
Seems to be.
I hope you have tab 14.
No, it's not in my bundle.
Oh, it's pretty fundamental.
Honestly, wasn't thought. I don't have either tab 14 or tab 15.
Oh, goodness. Does anyone have a clean? Sorry, I don't know if the claimants who provided the bundles have a clean version of the bundle.
I don't think there's anything else.
Nothing from, no, we don't have it.
We didn't prepare the bundles.
Sorry, no, you didn't. Okay.
Because we're
Supplementary
responding.
bundle. Yeah, well, let's hold the whole bundle up.
Washing your hands there, Mr. Beale.
I'm afraid so.
I do all the time.
Yes. I'm afraid we only have it in A5 form. It's,
Perhaps somebody could provide it in A4
Yes.
form at some stage later in the day, but I'll look at it in A5 for the moment.
apologise, my lord. It is extremely small, even though it can go in a handbag, it's extremely small. Page 246, we see the heading background, sets out the limiting regulation. Page 247, at the bottom of the page, sets out what the tenuous charges are. And I'm not going to go through that, I've already told you how they're broken up. And then the basuos charges at the bottom of page 247. And then page 248, under GB charges and the limiting regulation, a heading just below the first hole punch. Without looking in detail at that, on page 248, you see the reference to, at the bottom of the page, CMP 261, which I've explained to you, which says the scope of the connection exclusion was the subject of an appeal to the CMA in 2017, CMP 261. Then on page 249, we have the targeted charging review, which I've also explained to you. And then the against that background, if I could, the various proposals are summarised. If I could take you to the reasoning at page 262. I'm sorry, let's start, sorry, I apologise, let's start with 261. Under the table, we have the heading correct interpretation of the connection exclusion. And we have there, it says under that heading, we set out our analysis of the correct interpretation of the connection exclusion in Annex 2. So the legal analysis is set out in Annex 2. The legal analysis was, as you'll recall, the second ground of appeal brought by, or the second ground of review brought by SSE in front of the learned judge below, which failed what the correct interpretation was, but there still remains an issue between parties on what the correct analysis is, or the correct interpretation is, but it's set out in Annex 2 to GEMA's decision, or GEMA's view of the correct analysis, interpretation. Then on page 262, under the heading baseline, and it says in the first paragraph, as NGESO highlighted in the FMR, there is a real and imminent risk that annual average transmission charges paid by producers, as calculated in accordance with the limiting regulation, for which read our interpretation of what the correct interpretation of the limiting regulation is and the permitted range, will fall below zero unless changes are made to the current methodology. This would result in a breach of the limiting regulation. And it goes on to explain why. But for your note, I would ask you to highlight what's under the baseline and then over the page on 263 down to just above the heading, assessment of the options versus the correct and legal interpretation. And I think for your purposes, I need to highlight now is the paragraph above the heading, assessment of the options versus the correct legal interpretation. It says we, GEMA, have therefore assessed whether the original proposal, WACM 7 and or WACM 14, would present a lower risk than the baseline of annual average transmission charges falling outside of the permitted range. In carrying out this assessment, we have compared the available options against what we consider to be the correct interpretation of the connection exclusion to evaluate the extent of the divergences in each case. So there were 3 proposals in front of GEMA, which it had whittled down the 84 to 3 that fulfilled other requirements, but there were then 3 proposals before GEMA. The original proposal, WACM 7, WACM 14, which they compared against the baseline. None of those proposals, none of the 3, exactly reflected what GEMA held to be the correct interpretation of the connection exclusion, which it had set out in Annex 2. And the detailed impact of those 3 proposals, for your note, is set out in paragraphs 470 and 471 of the CMA decision. I'm not going to go through that in detail now, but it's sufficient to note that at the time of the GEMA decision, the choice of, before GEMA, was to reject all these proposals and stay with the status quo, which, on its view of the correct interpretation of the connection exclusion, would have led to an incorrect downwards adjustment of annual average GENUAS charges by about £423 million. Figure I've mentioned to you, and the figure that's broken down in those paragraphs of the CMA decision. It could either stay with the status quo, which would have led to an incorrect downward adjustment of the charges by about 423 million, and it anticipated a breach of the lower limit of the permitted range. That's what would have resulted from leaving the baseline in place. Or GEMA could accept any of these 3 proposals and assessed what the impact of those 3 proposals would be on the figures. The original proposal and WACM 7, on GEMA's assessment and on its view of the correct interpretation of the connection exclusion, would have led to an incorrect downwards adjustment of the charges because it didn't exactly reflect the connection exclusion. But that downwards adjustment, that incorrect downward adjustment, would only have been worth 1.7 million. So it didn't hit exactly the correct definition, but it was close by a figure of 1.7 million. And that was the original proposal, and Wacom 7 had that impact. Because I can explain, they excluded all local charges, and we held the connection exclusion did not exclude all local charges. It excluded the vast bulk of generator offshore, the connection with the wind farms, but there was still a small element of local charges that we said did not fall within the connection exclusion, that were not reflected under the original proposal. But it would have led to an incorrect downward adjustment, yes, but that incorrect downward adjustment only valued at 1.7 million. And the result of that is that it would not lead to any breach of the lower level of the permitted range. Whereas leaving the baseline in place would lead to a massive incorrect downward adjustment crashing through the zero floor. So then the decision that GEMA made is set out on page 267.
For your purposes, you simply point out that it was a stopgap.
Well, my lord, absolutely. And that's expressly so, which is spelt out in the decision summary on page 267.
Which takes you back, circles back to the point, over what period of time do you have to secure compliance?
Yes, my lord, it does. But it's just important for your lordships to understand what was facing GEMA and why.
Yeah, but it was common ground before the judge that the NG proposal, the NG ESO proposal, was more compliant than any of the other 83.
Yes, but I think it's important to understand just what we were talking about here.
Yeah.
So, for your note, my lord, well, perhaps I think it's probably, at the moment, just sufficient to note that the amendments made by the original proposal are in the supplementary bundle 1, tab 12, and they assume that all local charges fall within the connection exclusion.
And it's striking, isn't it, that the reasoning here as to why the original proposal was preferred to Wacom 7. They reject Wacom 14 as being less compliant, albeit that it didn't have, that its effect was
Less than the baseline.
The reason for rejecting Wacom 7 was that because this was a stopgap, it was administratively more straightforward to adopt the original proposal.
Yes, ma'am.
So this is all, as it were, expressly on the understanding that it's only going to be in place until National Grid have got their act together, if I can put it correctly.
My lord, it's expressly on that basis.
Yeah.
It's clear what is driving the decision.
Well, the instruction on the top of page 268 is also relevant.
My lord, yes.
It's an expectation.
It's an expectation, not a...
This is part of the binder
Yes.
in. It might have said, under different circumstances, NGESO shall bring forward, or NGESO shall comply with the following direction. Set it out.
And my lord, they did. There were problems with that because there's still an outstanding dispute as to what the connection exclusion actually means.
Yeah.
But they did bring forward a modification proposal. That was mired down in the process. And GEMA have in fact amended the CUSC in line with the judge's judgment below. It has been amended. I don't think this is giving evidence, I think it's somewhere in the bundles, but it has been amended in line with CMP 391 to effectively simply refer to the definition of the connection exclusion in the regulation in light of the judge's finding that there was a requirement that the connection exclusion should be reflected in the CUSC. Ofgem have simply taken the wording from the ITC regulation and put it in the CUSC. That was not the ideal approach that GEMA would have, because it doesn't really provide much regulatory assistance or certainty to operators. It would be better to say, and this is what we think the effect of that is and how that works, but it was effectively what the judge's decision below and the order that the judge made below required. So that has now been done. Unfortunately, there is still an ongoing dispute as to what the connection exclusion actually means, but that's not the purposes of today's appeal. So, my Lord, just then I think I can deal very briefly with our grounds 1 and 2, in light of that, having been a very detailed traverse of the background and the legislation. Now, and it does require, if I may ask you, to have the judgment below open, which is, we can put everything away except core bundle 1. And the judgment is at tab 12.
Tab 13.
I'm sorry, tab 13. Now, you have my submission on what the ITC regulation means. The judgment, relevant part of the judgment starts on page 197 in paragraph 40. The judgment says, and you will have read this, the relevant obligation on National Grid under the terms of transmission licence is that CUSC be calculated to facilitate achievement of objectives. And then he makes the point that National Grid's modification proposal did not properly reflect the connection exclusion. The premise was that National Grid's proposal was over-inclusive to the extent that, depending on the circumstances, charges might be incorrectly included in the connection exclusion. That's all so far so non-controversial. Thus, notwithstanding the adjustment tariff included to ensure no charge was levied outside the specified range, there remained the possibility that a generator could be required to pay a charge within the specified range, but nevertheless higher than ought to have been charged, according to what taking account of what is stated in paragraph 2 of Part B. Now, if that sentence, the last sentence of paragraph 40, is to be read as indicating, which on my reading it does, that a generator should not pay a charge within the specified range, or that in some way the CUSC, the ITC regulation and the exclusion in the connection exclusion says how the individual charge should be calculated. It's a reference there to higher than ought to have been charged, taking account of what is stated in paragraph 2. We say that's incorrect. So of course, as you have seen, and I hope I've made good, my lord, the annex to the ITC regulation does not say anything at all about how individual generator charges should be set. So there's no requirement as to how they ought to have been charged, taking account of what is stated in paragraph 2 of Part B of the annex. It doesn't say anything at all about how the individual generator charges should be set. And it says nothing about how generator charges should be set at all in my submission, whether individually or in some sort of collective way.
Just ask about individually. If, let's assume for the sake of argument that GEMA should have, that within the range, you must not only be within the range, but you must set the calculation correctly to exclude matters which should be excluded. And that's applied across the aggregate annual charge.
Yes.
Isn't there going to be some knock-on effect on individuals? It won't be.
There may be. There are drivers in setting the individual tariffs that are quite separate from the ITC regulation. They need to reflect local circumstances, they need to reflect the location. So for example, the locational charges want to set charges to encourage generators to locate in an area where there aren't many generators.
Yeah.
For example, or to locate in areas that are a lot of generators are located in Scotland, but that requires a huge amount of asset to get the electricity where it's needed. So there need to be incentives built into the national charge. Yeah.
So there's a possibility that the charge might be high. It doesn't say there will be. I mean, it may be that he hasn't quite addressed his mind to this.
Well,
but I'm just wondering, for the purpose of this appeal, whether it's a big difference that you have an aggregate fixed charge or an individual charge, there
Well-
could be an impact on the individual.
In my submission, it doesn't matter if the individual charge is above the range,
No, understood.
or under the range, or,
Understood.
yeah, or even the,
It's the average
Mm.
that matters.
yes,
The judge is simply making the point, one consequence of the average being higher than it should be, or lower than it should be, depending on the circumstances, is the individual charges, with a possibility that individual charges may be wrong.
if that is as far as the judges, if that is all the judge is saying at the end of paragraph 40, then that is fine.
Well, that's certainly how I read it.
If, and my lord, then,
I mean, but you in a sense, coming back to one of the basic questions we have for you, which is about timescale, you would challenge this proposition, charge higher than ought to be charged, because you say no if you look at over the correct decision-making timetable.
absolutely.
Yes, in the short term, but no, not by the time a new proposal comes forward and all necessary adjustments are then made.
It's not just
Then-
time, because at the end of the year, one individual generator could be charged on average, their individual average charge over the course of the year could be higher than the range. And we say that still is not a problem, because what is the range is overall.
And it comes back to the
So it's
objective.
timing and collective nature of the,
But eventually, according to the passages you showed us in your client's decision, on the basis of the stopgap, there is going to be whether it's been arrived at or not, I appreciate is in dispute, but let's assume for the purposes of the argument it has been. What has now happened is that the correct interpretation of the connection exclusion has been applied, so that the average annual charge is within the range, and everything is being interpreted correctly. So whatever has happened in the past has been rectified.
yes. But even then, my lord, it may be that now, assume the hypothetical situation where the ex ante adjustment exactly reflects the correct interpretation of the connection exclusion. It may still be the case that at the end of the year, an individual generator's charges on average are above or below the range. And it may still be the case, in fact, that at the end of the year, because of the limits with setting something ex ante, because of the amount of energy that's gone onto the system, charges on average across all generators may be above or below the range and have to be adjusted. The question is what you put in place first as an ex ante adjustment to try to ensure that you don't have to do that ex post reconciliation. And we will, in this hypothetical situation, even when there's an ex ante adjustment that reflects exactly the terms of the ITC regulation, it may not at the end of the year actually have the outcome, and there may need to be some ex post reconciliation. So, going back to the judgment, in paragraph 41, the judge below considered the CMA's reasoning and two propositions. First, whether Part B of the ITC reg contains only one obligation, or whether further distinct obligations arise as to how the annual charge is calculated. Second, if more than one obligation arises, whether the prior paragraph 1 obligation is the primary obligation. He cites quotes from the CMA's decision. And Mr. Hickman will no doubt address you further on this, but some confusion appears to have arisen as to whether or not it was GEMA's case that the necessary calculation, to which reference is made in paragraph 5.34 of the CMA's decision set out on the bottom of page 197, whether that has to be reformed as required or in the way set out in the point 2 of part B of the ITC reg. In fact, as is set out in paragraph 5.35 of the CMA's judgment decision on the top of page 198, GEMA's submission was, and as I've said it always has been, that the purpose of the calculation prescribed in Part B is to enable the assessment of whether or not the annual average charges fall within the relevant permitted range. It is the obligation to comply with the permitted range, which is the primary or principal obligation, if you want to call it that. It doesn't impose freestanding obligations to incorporate the definitions directly into the domestic charging arrangements. That was all we were saying. that there's the primary obligation to stay within the range. In deciding whether you've met that obligation, you have to apply the calculation obviously set out in the regulation. But there is no freestanding obligation to reflect that calculation in the domestic charging regime. And I've explained about the forward-looking ex-ante basis.
Just explain that for me. How can you accept that you've got to adhere to the methodology but not in some way reflect it in the domestic regime?
Because the domestic regime sets an ex-ante, the CUSC calculation or the objection that was made to the original proposal was that it set out an ex-ante adjustment mechanism that did not exactly reflect the connection exclusion.
But you accept that at some point in time you have to
And
apply
absolutely, and if I can take you to that.
correctly. Just before you know, sorry.
Yes, go on.
You accept that at some stage it has to be correctly applied.
Yes,
Your view is it's largely done ex post.
yes.
But it will be at some way in the regulatory
Yes.
mechanism, you accept you have to get the calculation right as per the exclusions.
My lord, yes, and that is not reflected in the judgment below, but it was reflected and explicitly accepted and in the CMA's decision, and I need to take you to that if I may, which is in core bundle 3. Paragraphs 5 page core bundle 3, tab 24, page 598. If you look at the page 597, it's the heading Our Decision, which starts at paragraph 5.34. This is the CMA's decision on what was ground 1C, I think. At that stage, there were 6 grounds. And the relevant section is at on page 598. It's paragraph 5.37b and 5.38.
Can we read those?
And I particularly emphasise the last 2 sentences of paragraph 5.38. That was the position, the evidence, the position that was in front of the CMA. So there has always been a reconciliation process, and there always has to be a reconciliation process for charges at the end of the year, and compliance can ultimately only be verified at the end of the relevant period. And that reconciliation is carried out by reference to, or has been, at least since the 2018 CMA decision, I can find the reference for you, but it's in the papers, by reference to the correct definition of the connection exclusion. So that ex post reconciliation is carried out. Where it appears that the permitted range might be breached or has been breached, a code modification can be raised and ex post reconciliation charges can be carried out. Ex post reconciliation of charges can be carried out. And that's exactly what was sought to be done in CMP 261. Because EDF, you'll recall, raised CMP 261 because it argued that on its incorrect, we say, definition of the connection exclusion, the permitted range was about to be breached and there needed to be a reconciliation of charges to ensure that the range was not breached. In the event that was not, we held it was not breached because of the interpretation that we successfully argued in front of the CMA of the connection exclusion. But CMP 261 is exactly an example of how, under the CUSC, once the reconciliation once the assessment has been carried out at the end of the year, reconciliation can be achieved through the CUSC modification proposal. So if you put the CMA's decision back to one side and go back to the judgment on page 199 at paragraph 42, paragraph 42, the judge rejects the CMA's reasoning. He sets out his construction of Part B of the annex, and he says, about halfway through paragraph 42, generators should pay annual average transmission charges that are both calculated in the prescribed way and fall within the specified range. Well, so far as it goes, that's correct. But then he goes on to say, failing to give effect to the connection exclusion is as much a breach of Article 838(2)10 as failing to give effect to the requirement that charges fall within the specified range. And again, there's some confusion about what is meant by giving effect. For these reasons, I do not accept CMA's first proposition, and that first proposition is what's set out back on page 197. So he rejects that proposition. And insofar as, again, it may be that the wording of the judgment can be interpreted in a different way, but if the judge is saying in paragraph 42 that the ITC annex, Part B, gives rise to an obligation to reflect the calculation in the domestic charging regime, we say that's wrong. If it simply means you have to give effect to the connection exclusion in determining whether or not there has been a breach of the permitted range, then we obviously, as I've said on a number of occasions, is correct. It's not entirely clear.
Why is the form and way in which you put it incorrect? You said if the judge is saying that Annex B, under Annex B, there's no duty to.
Yes.
If he said there's a duty reflected in the domestic charging regime, he's wrong.
Well, my lord, one needs to understand
the
that by
code?
looking at, yes, the code,
Right.
by looking
the
at.
regime is much larger than
Yes,
the
I'm
code.
sorry, the code.
Yeah.
By looking at the decision that the judge held was unlawful.
No, I understand. I mean, but you accept somewhere in the domestic charging regime it has to be reflected.
Somewhere in the
Doesn't have to
regime,
be
there
in-
has to be this.
You don't have to embed
Yes.
it in the code.
Yes,
You say that at the end of the year you can ensure compliance with it through the appropriate mechanism. At
yes,
the moment you have to do that via the code through the
yes,
modification.
I'm sorry, the loose language, yes, the
Yeah, no, I
code.
understand. I've got it now.
In paragraph 42, about 2/3 of the way down, there's a sentence which begins, generators should pay. Is there something wrong with that? I mean,
Well,
if
again,
he-
my lord, it's a little,
If he means individual generators should pay, he's wrong
yes,
on your argument.
on my argument, yes.
Because you say it's only all generators on average at the end of the year which matters for the purpose of compliance.
Exactly, my lord.
And if you set individual charges ex ante, it really is, you won't know whether you get close to compliance until you get to the end of the year and then you make an adjustment.
Yes, my lord.
And if you make an adjustment at the end, just help me with the
Yes.
practicality. If at the end of the year, is it a calendar year or some other 1st of April
April
year?
to April, yes, my lord.
If you make an adjustment because you suddenly figure out, whoops, we're about to go over the annual average range, how do you apply the adjustment? I mean, if you give a credit, how do you apply it as between generators?
Well, my lord, it would be, that would be a matter of regulatory discretion that takes into account a lot of factors.
But you
But
might you might start by saying, well, if there is individual generators who've actually ended up paying over the range, you might well apply the credit to them first, or
It
do
would
you
be
do
very
it
difficult
across
to
the
work
board, or
that
how
out
do you do it?
because there are because what you're assessing is the lump sum.
Yes, I know
Whether
you are,
the
but-
lump sum, so the lump sum, say the lump sum is over by you look at the amount, the lump sum you've imposed on generators and it should be X, but it's X plus 10.
Right, so
So you've got 10.
you've got a pot of 10.
So you've got a
You
pot
need
of
to give
10.
it back to
Yes.
the generators who
Absolutely.
featured.
And
How
of
do you
course,
do
the
it?
generators are paying tariff charges that are calculated on a completely separate and different basis
Yeah.
to the question about what's within the lump sum and whether the lump sum falls within the range. They're paid locational incentives, etc., etc. So then there is a question of, right, we've got to get back somehow to generators on average 10.
Well, you've got
How do we do that?
You've got to get back to individual generators, a part of the lump sum of 10.
Yes.
And what I'm asking you
And
is
then
on
the
your
question-
hypothesis,
yes.
how do you do it?
Well, I don't, my lord, and that is why I say that would be a question of regulatory discretion into which a number of different issues would arise, because it may be the fairest way of doing it. Because of course the ITC regulation clearly just says that as a whole generators should only pay within these ranges. It may be the fairest way of doing it is to split the 10 equally between all generators, for example. So to make sure that generators across the board in GB pay a certain level. It may be that you reduce all the charges across the board. There may be other reasons, other incentives that you want to reflect in the way in which you distribute that 10. But the obligation in the ITC reg is just that generally you should be, for generators across the board in GB should be paying this much.
If you
Go on.
if you got the formula, the connection exclusion correct at the start, ex ante,
Yes.
the likelihood of error is necessarily reduced, isn't it?
Yes. Yes.
So that the exercise that we've just been talking about would necessarily be lower,
less likely to
less
occur.
likely to occur, or
Yes. And that is why GEMA is seeking to put in place an ex-ante adjustment that does just that, so that we don't, except on the rare occasions, have to do this ex post process.
signalling, as it's described.
My lord. So paragraph 42 of the judgment, then paragraph 43 on page 199 is the second element of the CME's reasoning and its second proposition. And that's the proposition that's set out on 197, which is the primary obligation versus the secondary obligation. And the judge disagrees with that on the following basis, paragraph 43. At the level of theory, this contention is correct. In theory, there would no doubt be a range of steps open to GEMA in exercise of its regulatory authority to ensure compliance with the requirements of the regulation. However, in the circumstances which GEMA came to its decision on CMP 317327, the contention is wrong. The purpose of GEMA's direction, you've seen the CUSC direction this is, was to bring forward a modification proposal to give proper effect to the regulation within the terms of the CUSC, in accordance with its decision on modification proposal CMP 261.
If there were other ways, and this goes back to the point my Lord or Justice Green made to you some time ago now, if there were other ways, as the judge seems to accept, in which GEMA could comply with its obligation under the regulation, then what the judge is really deciding here is that they've somehow tied their hands by the CUSC, which is a contract in which they're not a party. It's slightly odd, because he seems to accept that there would have been other ways in which they could have done it, but seems to think somehow they don't help you because you've tied yourself to the CUSC.
Well, my lord, I think that's what he's saying,
Yes.
and we say that's wrong. You've seen the CUSC direction. It's at Supplementary Bundle 1, Tab 7.
This is where it's an offshoot of the same point. He doesn't like the word expected, which was seen in the CUSC direction. NGSEO is expected to bring forward. He says, well, that's not mandatory, it's just an expectation. But that's one of the problems of the code modification process. GEMA is uncertain as to how it is to get to a position where it can exercise mandatory directional powers. And it doesn't seem to think it can, because its hands are tied by a private law contract.
My lord, I take your point, and if I may, I'll come back on that specific point.
Sorry,
But-
can I, sorry, if you, sorry, had you finished answering the question? Sorry, if you finished.
I have, yes.
Sorry.
I have to.
So I was just trying to get in before the next one came. If you go back to, so I was going to ask you to go back to that paragraph 42 that we were
Yes.
previously looking at, where the judge talks about the primary obligation, and it talks about another obligation. You can see whether he's decided as primary and secondary. If the relevant bit of the CMA's decision is the bit that you asked us to look at, isn't it?
It's actually reproduced on page 197 and 198.
Yes, the only problem with 197, 198 is he didn't in fact include the two paragraphs,
No,
537,
no.
so I was actually looking at the
Yes,
original thing.
apologies, yeah.
But the CMA doesn't at paragraph 535 talk about primary and secondary obligations, does it, at all?
Not really, no.
It
I mean, it talks
basically
about-
said, it just says, I mean, it talks about a primary or principal obligation, and then it just says that the definitions are the constituent elements for assessing whether the primary obligation is met.
Yes,
I mean, it's perhaps unfortunate that it's used the word primary or principal. I mean, there is an obligation and there are definitional elements.
yes, my lord, and in our submission, that's really what it is.
Obligations.
Yes, it's part and parcel of the obligation. The question really is, what it boils down to is, were we required to reject the original proposal?
Because the judge sort of then, in 42, starts talking about hierarchy of obligations. He seems to have sort of transmuted
Yes.
an obligation with a set of definitions into a hierarchy of obligations, which seems to just...
Yes, it all becomes extremely complicated when you're talking about primary obligations, secondary obligations, this, that and the other. And one needs to just try and anchor it to what happened in this case. Were we correct or not to accept the original proposal as a stopgap measure? Or was that unlawful?
Well, you say, in a sense, you could accept almost anything you want as long as you're doing it ex ante, provided that at the end of the year it's all
Yes.
right on the night.
Yes,
And you-
but as a responsible regulator, we want to try and get as close as we can. So we
Well,
don't
hence-
have to carry
hence
out
the
the ex
point- hence
post
the point that-
reconciliation.
Hence the point that if you get where you're intending to get, and you actually incorporate the correct definition of the connection exclusion from the start, ex
Yes.
ante, you're more likely to get correct and not have that little problem that I'm still not sure, just saying to the regulator's discretion seems to be a bit of a,
A red herring.
well, not a red herring, it's just which palm tree they're sitting under.
Yes, I mean, the point being made against us in the judicial review is that we were wrong to accept the original proposal as a stopgap measure. We had to reject it because it did not exactly reflect the correct interpretation of the connection exclusion. That is the argument that was made against us, and that, although it's a little more complicated in the judgment, is the argument that the judge accepted below, because he quashed that element of the CMA's decision upholding our decision. And that is what it comes down to. Whether you describe it as primary obligation, secondary obligation, blah, 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 blah.
But you see, again, well, but you see, the point is, if you look in the 42 again, which seems to be the key to the judgment, he talks about a hierarchy of obligations, the primary obligation being the one that you've described being the end of the year. He then says generators should pay annual average transmission charges, which appears to be looking at the ex-ante charging structure under the CUSC.
Yes, I think, well, that's how we read it.
And then he says, well, I mean, this is all subject to other argument. I'm just saying this is the way you're reading it.
Yeah.
And then he says, on the correct construction of Part B, the former is equally as important as the latter. The point is that Part B, you say, only applies to the former, not to the latter. The correct construction of Part B, it's only the average annual transmission charge across all generators that matters. And if he's thought that there's some requirement that individual generators have to pay a charge which falls within the specified range, then he's wrong. It's difficult to understand quite what those sentences
I have
actually mean.
some of, yes, I have some difficulty.
Well, I have a problem at the moment, maybe somebody will tell me, but I have a problem with it at the moment.
Stand back and look at the purpose of this. The purpose of this is to ensure that there's not an undue hindrance to cross-border trade. And I say undue because it's recognised there are disparities in national charging mechanisms, but as the Commission, the impact assessment indicates, there is a degree of competitive neutrality. So such differences in charging are not creating major problems.
Yes.
Hindrances are not going to arise by virtue of a price paid by or to an individual. They're going to be impacted by the signalling presented by what's happening across the market as a whole.
Yes.
I mean, I suppose it's possible that what happens in one case might have an investment impact, but that's not what they're talking about at this level of generality. It is system pricing rather than individual pricing, because it's that which impacts upon hindrances to internal trade.
I think that's absolutely correct, my lord, that the charges, I'm starting to repeat myself, not starting to repeat myself, the charges have to be on average over the course of a year within this sort of range. So that when generators are deciding where to locate, where to invest, they know that generally the charges they'll be facing in GB will be somewhere
What
within
the pricing system is, in a sense, the aggregate pricing, because that's a fairer and more sensible way of determining investment decisions.
Yes.
One of the curiosities about paragraph 43 is the judge, apart from the judge seems to have said, given that you've nailed your colours to the flag of
Yes.
CUSC, you can't do it by any other route.
Yes.
He doesn't seem to recognise at all the stopgap nature of the direction.
No, my lord. No, it doesn't. But
It's almost as if he's saying, well, you had to comply with the CUSC at every stage, and you didn't comply with it at the time of this direction, and therefore what you did was illegal, and doesn't recognise that because it's a stopgap
yes.
decision,
Oh,
that this will potentially all be remedied at the end of the relevant year.
my lord, he doesn't appear to recognise the stopgap nature of this, although it was clear, we say, on the face of the decision and clearly submitted. But it's puzzling because, well, we've made our submissions on that. The second ground, which maybe I hope I can deal with very briefly before we rise.
This arises if you're wrong on your first ground.
It does, and that is contained in paragraphs 44 and 45 of the judgment. As the judge says, it's not strictly necessary for him to consider the CMA's third proposition, and similarly, if I succeed on my first ground of appeal, it's not necessary for me to pursue my second. But assuming I do not, so assuming that the learned judge was right to find that there was an obligation imposed by the ITC regulation that extended beyond compliance with the permitted range, in some way that the CUSC had to reflect the connection exclusion absolutely correctly ex ante, and we had to reject the original proposal. So what was the situation there? Well, the point is a short one, my lord. I've shown you that the first point we make is this, that under the terms of paragraph 8.23.7 of the CUSC, that which is at supplementary bundle 2, tab 26, page 460, I've shown you that. You'll recall that it simply provides the question for GEMA in deciding to approve a modification proposal is whether it would better facilitate achievement of the ACOs, including compliance with the ITC regulation. Now, in paragraph 45 of the judgment, the judge rightly accepted as a matter of fact that approval of the original proposal made for a situation that complied better with the regulation and made things better insofar as the amendment made to the CUSC prevented transmission charges falling below the range, as I've explained. But he held, nevertheless, it was unlawful for GEMA to approve the original proposal. Now, assume the judge is correct. He seems to be saying that there are, whether you put it as two obligations or that the ITC regulation has two consequences. Annual average transmission charges have to fall within the permitted range, and the connection exclusion has to be incorporated into the CUSC, the second finding or consequence. The choices, as you'll have seen, that were before GEMA at the time of the decision were to reject all the modification proposals in front of it and to revert to the baseline, and you would inevitably breach both of those obligations. You would fall below the permitted range because of the 423 million. You would also revert to a situation where the CUSC did not correctly reflect the terms of the connection exclusion. So you reject all the modification proposals, revert to the baseline, you breach both of those obligations, at least until a new modification proposal can be raised. Or the choice that GEMA made was to accept the original proposal, which on the judge's hypothetical now would breach only the second obligation. The charges on average would fall within the permitted range under the original proposal, but the CUSC would still not reflect exactly the terms of the connection exclusion. So we say, well, we were damned if we do, damned if we don't on the hypothetical proposal, on the hypothetical situation, because if we act, we will certainly act unlawfully if we reject all the proposals and stay with the status quo. There would be a better position, although arguably on the judge's hypothetical we would still be not complying correctly exactly with the law. We would certainly be in a better position to accept the original proposal. And in that situation, the judge said a miss is as good as a mile, and we say it really cannot be in a case like this, that acting so as to prevent a more egregious breach, or a more egregious breach of the requirements under European law was wrong, rather than taking the original proposal, which would, even on the judge's interpretation of the ITC regulation, be a breach, but a less egregious breach.
Well, what you did was, the assessment was that what you were doing would better facilitate
My lord, yes.
compliance in due course.
My lord, exactly.
And the judge just doesn't seem to recognise that, because it comes back to the same point about failure to recognise that this was a stopgap. He seems to think that at all material times there was an absolute obligation to comply to apply the correct interpretation of the connection exclusion.
My lord, yes.
The expression as miss is as good as a mile is one which of course one finds in other public law contexts, in particular immigration and asylum, where the environment is such that if you want to apply for example, as a student for an extension of your visa to work for 2 years, you have to do it within X days, and if you do it 1 minute outside 28 days, you're barred. And this argument, this is as good as a mile, is effectively a doctrine, a principle of immigration law, and it arises from circumstances where you have rigid timetables set down in legislation, and you have a philosophy or a policy which precludes de minimis breach. And there's been lots of cases in the High Court and Court of Appeal on precisely that point. But this regime is not one which sets down any timetables at all.
No, my lord. Yes, I don't know. Yes, my lord. We have our submissions on ground too. It's 3 minutes to 1. I've eaten into Mr. Hickman's time quite egregiously, I'm afraid, but I hope that he'll be able to.
We
have
barely
time.
interrupted you at all, have we?
No. No more than I would expect, my lord.
Was that a
And I know
convenient
I've never
moment? Was that a convenient moment to break in that case?
sorry, my lord.
Is that a convenient
I
moment
think,
to
yes, it
break?
must, my lord, yes.
I think
We have managed now to dig out A4 versions of the missing, supplemental bundle 1, I think it was. Two, sorry, supplemental bundle 2, tabs 14 and 15. Thank you so much.
So just
Before I sit down, my lord, can I just, as I said, Ms Rogers is going to address your lordships on the cross appeal. Can I ask for your lordship's permission for her to do so from this bench tomorrow morning?
Yes. I was going to suggest that anyway. The acoustic in this court is not always brilliant, although it's better actually on your side of the court than the other one, and you've got the problem with the deep piling. So
that's not a medical condition.
very well. 2 o'clock. Thank you.
all rise. I'm ending the live stream,